All right. Good evening. How's everyone? This is Tuesday, the 19th of March, 2024. And welcome. I want to take just a moment or two to allow some more people to get in here. I want to address just a couple of comments before I do. I want to point out that, let's see, Mickey says, just finished listening to Ashley Merchant on the Megyn Kelly show. Yeah, she did a wonderful job, didn't she? I think that's something everyone should go and check out, because now she is able, now that this motion hearing is over, to kind of give a little bit more of the behind the scenes part of it. It's a very interesting, I think it was almost an hour and a half, and I was on just after her, but of course, Ashley was the star of that show, and so I encourage everybody to go listen to that interview. Here's more Orlando references. Ashley, her interview with Megyn Kelly behind Bradley's forlorn testimony. Yep, that's true. It was a great interview. I want everybody to go listen to it. But tonight we're going to start out. We're going to talk about, first and foremost, before we get into a surprise guest that I have joining me in a few minutes, I want to talk about the bar complaint, the bar grievance that has been filed by a Fulton County resident by the name of Steve Kramer. Okay, so I want to go ahead and bring that up, and let's go ahead and zoom in on this, and we can talk a little bit about bar complaints, what they are not, and what this one might mean. You can see here it says confidential. Well, it is confidential, at least with respect to the bar. They will not release this, but Mr. Kramer released it, and he gives me full permission to talk about it. He being the complainant, he even went so far as to do a press release that went along with this. So this is absolutely out in the public domain. And this is the complaint against Fulton County District Attorney Fonnie T. Willis, and that, of course, is her work address. Now, I'm not going to go through all 23 pages of this, but suffice it to say, when a bar complaint has a table of contents, you know that it has been well thought out, well researched, and in my opinion, very well written. The ones, the parts of this I want to get into are this candor towards the tribunal. And I want to get into truthfulness in statements to others and misconduct. And we may touch on lawyer as a public official, but you can see that he's got a table of contents, which includes an opening and even a closing, in addition to other information. So if we can go down, we'll start with candor towards the tribunal, Rule 3.3, and we'll go down to page 5. Here we go. This is the rule. He cites it, the rules of professional conduct as it pertains to attorneys in Georgia. And this particular one is, it basically cites all four. It says that the rule prevents a lawyer from lying or hiding information from a court. A lawyer shall not knowingly, one, make a false statement of material fact or law to a tribunal, shall not fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. Now, of course, Ms. Willis does not have a client in the traditional sense, but Part 3 says the lawyer shall not fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the lawyer. So that means you can't make basically specious legal arguments that are not based in, the proper case law. 4, it says, shall not offer evidence that a lawyer knows to be false. If a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall take reasonable remedial measures. Now, here he goes on to say, in our opinion, DA Fonnie Willis made a false statement under oath violating Rule 3.3. The following is a prima facie argument as to why. Willis supplied a brief to the McAfee court and then subsequently testified on February 5th, 2024, that her inappropriate relationship with Mr. Nathan Wade started in 22 after she hired him as a special prosecutor. Wade provided a similar story, but both those statements were self-serving. She was impeached. That means discredited by Robin Bryant Yurdy, a longtime friend of hers who gave clear testimony that the relationship began in 2019. Yurdy didn't equivocate, saying she had no doubt of the 2019 timeline, and she witnessed them showing public displays of affection. And the state notably did not materially challenge the testimony. Now, I want to pause right here and just remind you that in Judge McAfee's order, he said that Robin Yurdy was her testimony lacked context, and he essentially discredited it. He said there was an odor of mendacity. We've talked about that. Of course, that means it has the odor of untruthfulness about it, if you will. But he essentially, in my opinion, failed to give proper weight to the unambiguous and unrebutted testimony of Robin Yurdy. So this particular bar complaint is essentially incorporating that and is saying that is part of how she has been untruthful with the court. All right, let's get back into this. He goes into the fact that Yurdy had no reason to lie and was extremely reluctant to testify, and again, was not contradicted by counsel for the state. He refers to the Charles Middlestat, the defense the defense witness investigator who was going to come and testify about the cell phone tower data, phone call metadata, and text metadata. He incorporates all that, and you can see he cites to cell hawk data here. He cites to news reports. He has got footnotes down here, and he goes on to then get into Mr. Adam Abate, Fulton County Chief Deputy Assistant District Attorney, tried to impeach the cell phone tower data, partially by saying there was no expert used by the defense. And then he later referred to the defense's expert, thus contradicting himself, tacitly admitting that the defense did indeed have an expert. But in oral arguments, Mr. Abate did not present the name of an expert to refute the defense. So here we're getting into a very thorough explanation as to why Mr. Kramer believes that Ms. Willis was untruthful with the court. The state shows times that Wade was in the Hapeville area when Willis wasn't there. However, that doesn't explain away the sequence of his late night visits there. And then an immediate late night call to the DA Willis once again found him in the area of his own home. This is, in my opinion, an excellent summary of that particular issue. I have posted all of this, with the exception of some introductory matters that's not relevant, on my Twitter or X feed, if anybody wants to go and look at it. But it's pointed out that it points out that the remedy or the penalty, if you will, for violation of the duty of candor to the court is disbarment. Okay, so this is again, this is the bar complaint filed by Stephen Kramer. Let's go back to the table of contents. The next thing that I want to get into is the special responsibilities of a prosecutor. So let's see if I can navigate down towards page 12. Special responsibilities of a prosecutor, Rule 3.8G. The Pacific Rule states the prosecutor in a criminal case shall, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, shall refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. The maximum penalty for violation of this rule is also disbarment. So I want to take just a minute and pause right there. We're going to get back into fairness by a prosecutor, and I want to bring in a special guest, a lawyer and a colleague of mine. Her name is Sarah Hobson. So Sarah looks like she's ready. I can see her in the back. So let's add her to the stage and let's everyone welcome Sarah Hobson. Sarah, are you with us?
I'm with you. Can you hear me okay?
Absolutely. Thanks for joining me on short notice, but appreciate you being here. Sarah is a former prosecutor in Georgia, currently practices in the area of family law along with her husband, Chris. Sarah, tell our listeners a little bit about who you are before we get back into dissecting the bar complaint, basically, that was filed against Fonnie Willis by Mr. Stephen Kramer.
Sure. So I started out as a prosecutor for the Cobb Solicitor General's office. I did a little over a year there, and then I went out on my own doing criminal defense and family law. Around, I believe it was 2018, I ran for Cherokee County Solicitor General's office, which is the head prosecutor for misdemeanors in Cherokee County. So I'm very familiar with the requirements that are incumbent upon a candidate for an elected office in Georgia. The finance disclosures that have to be filed. I've also assisted other candidates and judges with their campaigns. And really, I've been on both sides of this coin as a prosecutor and a defense attorney. So it's been really jaw-dropping to watch this case unfold. And it's turned into, it's not even about the indictment so much as it is about the behavior of the prosecuting attorney.
Yep, that's true. And speaking of behavior of the prosecuting attorney, now that you're here, feel free to chime in at any time, but I want to go ahead and get back into this. We were just getting into the bar complaint, and we were talking about Rule 3.8, special responsibilities as a prosecutor. Now, you and I both have been prosecutors, but this specifically talks about the extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. And of course, in Judge McAfee's ruling, where he elected not to disqualify Ms. Willis, he nevertheless said that her conduct, especially with her, what I'm calling the church speech, where she claimed she injected racism and race into this discussion, the judge said that was clearly improper, but he exacted no penalty from Ms. Willis other than to suggest that he might consider doing a gag order at some point. Yeah. And so tell me your thoughts on that specific issue, if you don't mind. I want to hear what you thought of that particular speech at the church here in Atlanta.
I believe in his order, I don't have it right in front of me, but I have read it several times. I believe in his order, what he was pointing to is that the fact that she didn't use the defendants by name in that speech. I just don't think that passes the sniff test for whether or not misconduct occurred. This is a national case going against a former president, and it was very clear and obvious who she was referring to when she made those accusations. I believe even the accusations that she made on the stand while testifying in reference to Ashley Merchant, calling her a liar and saying that she lied on her, I believe that's another instance of misconduct. I don't believe that was addressed in the order. But again, this was publicized on national television. The truth has come out. The text messages have come out. The evidence has come out. Ashley was not lying in the motions that she filed. So, I mean, it just looks like a lot of mental contortions that I see in that order to get around what really the law requires, which is disqualification.
Well, I agree. I don't know what good it does to say that that it clearly violates the rules of ethics, but then to not do anything about it. I think that in and of itself, and that, by the way, is called forensic misconduct. That's when you read the pleadings in this case and you see the allegations about that. That's what it's talking about. And it really is misconduct. And this particular misconduct is bad, really bad, because this was in a large church with lots of people that are undoubtedly Fulton County residents. And guess where they get the jurors from?
Right.
They get them from Fulton County. They're Fulton County residents. And so she's basically preaching to the pool of potential jurors, and she's calling one of the defendants or more of the defendants and their counsel, calling them racist for filing pleadings that clearly are not frivolous. If it was frivolous, we would not have had one of them already kicked off. One of the prosecutors already kicked off the case.
Right.
So in my opinion, it was very, very improper. She should have been disqualified for that. But I want to continue along with this bar complaint. And I want to go ahead and let's get that off there and come back to this guy. There we go. All right. So this is the table of contents. This we've talked about special responsibilities of a prosecutor. I want to go to misconduct, which is on page 17. So let me scroll down there. And this one I thought was particularly interesting. This is, I don't know if you guys can see this, but it says this cartoon that Willis tweeted was drawn by cartoonist Steve Steglin of the Charleston City paper. And DA Willis tweeted, not even retweeted, that picture and made it her own. To bind the image to herself, she captioned the picture with, "This is my first cartoon and likely the only time a boat will ever bear my name." This is the quote directly from her Twitter feed. And what it shows a boat that says Fulton County. It says DA Willis on it, a caricature of her. And this is apparently supposed to be Senator Lindsey Graham, who is on the hook, is on Willis's hook, with a caricature of former President Trump in the water, stating, "I know you'll do the right thing for the swamp, Lindsey." So I want you to tell me, folks, do you think this is does this represent a fair and impartial, open-minded prosecutor who's just seeking something called justice, or does this paint the picture of someone who is perhaps on some kind of a mission? So anyway, I wanted to point that out. Sarah, do you want to talk about that cartoon there?
That's the first time I'm seeing it. It just, again, it's just an illustration of the arrogance. It's really unbelievable. This prosecution should not be based on political motives. And I've talked a lot about this. You know, you and I have known Ashley Merchant for a very long time. She and other of the defense attorneys, they're not doing this for political reasons. They are not Republicans. They are not supporting Trump. The fact that she would put her name on a political cartoon like that, I mean, it's just blatant arrogance and disregard for her duties as a prosecutor. That's really, I mean, I keep thinking nothing else can surprise me, and you've done it again. I mean, that's incredible.
Yep. And you mentioned something about the defense lawyers. I know a lot of them, and I know you do too. And I think it's fair to say, particularly of the ones that I know, a lot of them are probably Democrats and certainly did not and would not vote for Donald Trump. So to them, this is not about politics. It's not about the defendant. It's not about guilt or innocence. It's about the fairness of the system. And without a fair-minded prosecutor, you don't even get to a grand jury. You don't get to preliminary hearings, and you certainly don't get to a trial unless you have a fair system. And that begins with the prosecutor. You can't have a fair system or a fair process or a fair prosecution unless the prosecutor is fair and objective and is honestly and genuinely and in good faith seeking justice and not seeking some political end. That cartoon tells me that she is seeking a political end, and it's not right. And I don't care if you like Donald Trump, hate Donald Trump, somewhere in between, you've got to acknowledge that that is wrong. You can't have this type of public sort of a disparagement of defendants or their counsel and stay in a case. So I certainly hope the Court of Appeals, when they consider if they get around to considering anyway, the appeal that was started yesterday, I hope that comes into consideration. But this is not the appeal. This is a complaint with the State Bar of Georgia. And I want to, before we move on, Sarah's going to talk to us about the elections that are coming up with not only the the judge's race. Judge McAfee has drawn opposition, but so has District Attorney Willis. But Rule 8.4, as Mr. Kramer points out here in his bar complaint, says the rule deals with rules violations being convicted, committing crimes, and for dishonesty or deceit. It shall be a violation of the Georgia Rules of Professional Conduct for a lawyer to violate or knowingly attempt to violate the Georgia Rules of Professional Conduct. Goes on to talk about engage in professional conduct involving dishonesty, fraud, deceit, or misrepresentation. And again, the specific maximum penalty it references is disbarment. Incorporating the allegations from other sections of the rules, if any of them are upheld by the state bar, DA Willis is alleged to have violated 8.4A1. Similarly, she appears to have been dishonest as to when her improper relation began, now that text, cell tower data, and phone records have revealed a different story. The impartial data tends to show us much more of a relationship than Willis and Wade alleged in their testimony. Therefore, they have been alleged to have misrepresented what their relationship was. The alleged deceit is that Willis promoted racism as the motive of the defendants when they never had and never have shown even the slightest trace of racism. Therefore, it is alleged that she is to have violated 8.4A4. And this is quite the read. And you can go on, and again, I've shared it, and I will quote to it and reshare it on my X feed a little bit later. But you can see it for yourself. This is a very well written, in my opinion, very thorough, complete with the table of contents, 29-page document. And I've never seen a bar complaint that is quite that thorough. But there you have it, folks. All right. While we got Sarah here, I want to have her go ahead and talk to us. You and I were texting earlier about the challengers that are facing both Willis as well as Judge Scott McAfee. So you can pick, Sarah. Who do you want to start with? You want to start with a judge, or you want to start with Willis?
I think let's start with the judge. I'm just going to grab my my notes on here. So I believe Robert Patillo has qualified to run against Judge McAfee. He has a radio talk show, I believe. His Twitter is full of disparaging remarks towards President Donald Trump, Republicans. So I believe he's not setting himself up to, if he were to be elected for this judgeship, to be able to hear this case. I think he would have to be disqualified immediately. I thought there was a second candidate. I have not confirmed that she met the qualifications deadline, so I'm not going to talk about her in particular until I confirm that. But it's just interesting that the timing of course, anyone can qualify before the deadline. And sometimes it is a strategy to not talk about it amongst the community. You want to surprise the incumbent judge. But here it looks like, again, it was politically motivated to put pressure on the judge, outside pressure exerted on the judge to handle this Fani Willis disqualification motion in a particular way. I believe a statement was even made by Attorney Patillo that he was going to be watching how the judge ruled on this disqualification motion.
All right, so we've got in the DA's race, of course, that's a partisan race where we've got a Republican primary, you've got a Democrat primary. Willis, of course, is running as a Democrat. What's the name of her Democrat challenger?
Christian Wise Smith.
All right, what do we know about Mr. Smith, and why do you think he's running against Willis?
So he actually has ran in a race with Willis previously. He ran, it was Willis, Christian Wise Smith, and I believe another candidate. I believe he came in third at that point. I believe they also worked together at some point with under Paul Howard back in the day for the district attorney's office. I think he's also ran for attorney general. There's some people who they are always running for something. I don't know him personally, but there are certain people in our legal community that, you know, we're all familiar with. They're always running for something. In this instance, you know, I mean, she left a wide opening. I mean, she's out there for anyone to take a shot at, including Democrats. I believe he has made some comments about how she's handled this case. You know, so he may have some valid personal reasons to run against her. He's also commented publicly very heavily on disparaging Donald Trump and Republicans, and he seems to be very fixated on white supremacists. So, you know, of course, racism.
Wait. So we got a Democrat running on against Willis, and he's running against the white supremacy. Is that the platform?
I see that there's been some posts in his history on Twitter really seemingly to be, in my opinion, fixated on going after white supremacists.
All right. So the winner of when is that in May? Is that correct? That's
yes.
when the partisan primaries are.
Middle
and
of
so
May.
The winner of that, so theoretically he could theoretically beat Willis, and then the winner of the Democrat primary, whether it's Willis or otherwise, goes on to face who in November?
Courtney Kramer. So Courtney Kramer is the only Republican that qualified to run for district attorney in Fulton County. So does not have a primary challenger. She's a shoo-in for the Republican Party, and she will go against the candidate that gets the most votes for the Democrat Party in November.
All right. So she's running unopposed. Her primary, of course, is also in May, but since she's the only Republican, she'll be on the general election ballot in November. I guess lots of things might happen with Fani Willis between now and November, depending on what may happen with this bar complaint and other things, although that will tend to move pretty slowly. By the way, I want to point out Courtney Kramer is no relation to Stephen Kramer, who is the person who filed this bar complaint. I've confirmed this. And I've talked to him. He's no relation to her whatsoever. Just a happenstance to have the same last name. Courtney is going to join us. She was going to join us tonight. She had something come up, but she does promise that she's going to come in and talk about her candidacy here, perhaps as early as next week or as soon as we can find the time. But Sarah, since we've got you and you know a lot about these elections, tell us about the judge's primary, and let's talk about whether it's a partisan primary or what it might mean if one person in May does not get 50% plus one of the vote.
Are we confirmed that the Tiffany, but she qualified against him?
Yes. So there's three. There's three now in that race. That's correct.
Okay. So if there is not one that gets 51%, then there will be a runoff. It's going to be, I expect a lot of money is going to be going into these campaigns. It is a very large demographic county. So they also have a very short window of time to campaign. I know when I ran, there was no Democrat candidate. It was just two Republicans. I believe we started in December, and then we finished up in May. And I had an ample opportunity to knock on doors, to go meet the constituents. They have a very tight window to campaign. And being that the judge in particular has one of the nation's largest cases in history, certainly, in my opinion, the largest case in the state of Georgia, he's likely not going to have a lot of time to campaign. He's very busy with this case. There's things getting filed every single day. I do think that that's a little bit of a disadvantage for an incumbent judge in a hotly contested race like this.
And this is a nonpartisan primary. So this race for the seat that McAfee now holds, that is going to be decided in this primary or potentially in a runoff if somebody doesn't get over 50%. And it's important to remember that McAfee just took office, I think, a couple of months before this indictment, and he was placed in that office appointed by Governor Brian Kemp to fill a vacancy on the Superior Court bench of Fulton County. And he always knew that he was going to have to run again, or to run, I guess, for the first time in 2024. Up until maybe, I don't know, a couple of days after the 1 week qualifying, it looked like he might be unopposed. But then you had someone come out of the woodworks with some affiliations, far left affiliations, I do believe, as far left as the Rainbow Push Coalition. And it's widely felt that there's a good chance that maybe, hypothetically, possibly, Fani Willis has basically turned her campaign apparatus and political machine, if you will, against Judge McAfee. You have any thoughts about that?
I do. So it is really interesting. Of course, there was a lot of speculation as to why he pushed the decision date on the motion to disqualify Fani Willis past the qualification date. He stated it had nothing to do with the election. But you have to remember, realistically, he is a young professional. He is a very new judge, very fresh judge. He's never actually ran a campaign before. He's never had a campaign before. He has been appointed. And it is percentage-wise, there's very few people statistically in our country who ever run for an elected office. Having gone through it one time, I now understand why. It is really a grueling process. You're totally exposing yourself to all sorts of hate emails and accusations and hit pieces. But he's got a short window. He only found out about this on March 8th that someone was running against him. And it's really going to be an interesting race. I think it's very interesting as well that Fani is going to benefit from this, the judge's race as well as her own. Here she is. She's already has the nation, perhaps the globe's attention in her prosecution of Donald Trump. If you want to go into, like, again, a conflict of interest, where she's benefiting from the prosecution of Donald Trump and President Trump and these other defendants. Well, now that she does have opposition, there's even more attention that's going in her way. And that's not attention that she has to pay for. When I ran for office, if I wanted to do a commercial or have a print ad, I had to pay for that. And it's quite expensive. It can really be a barrier to entry for a lot of great candidates because it costs a lot of money to run for office. And here she has it all for free. Continuing this prosecution just gives her even more attention for her campaign.
Well, an incumbency does have its benefits, but judges are even less able to speak freely about pending cases than lawyers are, even prosecutors. So the judge really doesn't have that particular built-in advantage. But let's scenario this a little bit. What if one of the judge's opponents wins this race? When would the judge leave office, and then who would get this Trump RICO case that Willis is prosecuting?
I believe it's January of the next year. So he would still be on it until January. Based on who is running against him, I think that they've already put enough out there publicly that there would be there'd be a recusal if they were elected, a motion to recuse. Because he's already commented about this case, about the defendants.
His Facebook and social media posts, right?
Twitter, yes.
Yeah, I've seen some of those, and they're very overtly anti-Donald Trump. And so theoretically, if he would win the race and take over for Judge McAfee at the end of the year, or I guess the beginning of next year on January 1st, he would automatically inherit this case, but he would immediately either have to do the right thing and recuse himself, or maybe more likely he would face a motion to recuse himself by a defendant. And let's talk about what that would look like, because under Georgia law, if I think that a judge who's handling a case that I'm involved in is somehow unfair against my client, I have to file a motion seeking the recusal and the grounds that I believe the recusal is based on. And then it goes to another judge who has to basically hear that motion. In other words, the judge who you're saying is not going to be fair and needs to be recused, that judge doesn't get to hear that motion. And I think it makes sense. Why? So some other judge would then have to look at it and decide if this person's prior statements against Trump or other people would be the basis for a disqualification or a recusal, in this case, an involuntary one under my hypothetical. So the bottom line, I think, here is we just don't know how this is going to play out. The politics really does add a lot of moving pieces here, and we won't know really until, well, we'll know at the end of May whether there's an outright winner in the judicial race, because that's the nonpartisan primary. You've got Republicans and Democrats and everybody thrown in together, and they don't really declare what they are, but we all know. We all know
Right.
what they are. And so
back in the day, you wouldn't know. Back in the day, you wouldn't know. But now with social media and technology, it's very, very obvious. It's very easy to find out.
I think we ought to have them in the partisan. I think we ought to just have them put on their partisan hat, and that way the world knows what they are voting for or not voting for, because you know, it's a lot more transparent. But it is what it is. If we don't get 50% plus one in that race, there will be a runoff. I want to say that's in maybe July, sometime over the summer, and then it's all about turnout, because then you would have the top two vote getters, and that the primary, excuse me, the nonpartisan runoff is always really, really low attendance. Okay. So this particular case could change that, because everybody's going to know what's at stake if you've got, say, a Scott McAfee versus one other challenger in there. So again, this year in this case just turns all the traditional models on their head.
It's interesting too, if Judge McAfee is not reelected, you know, we have, as attorneys, once something is brought to our attention that we feel like we have cause to file a motion to recuse a judge that's hearing our client's case. When does that happen, right? Because if let's say Mr. Batillo is elected, he may be elected in November. So now you have this information as a defense attorney that he's been posting these things. He's been talking publicly. We don't even know. I don't know what he's been saying on his radio channel. You know, what does the timing look like for that? When, you know, I mean, can you file a motion to recuse a judge before they've even taken the bench?
That's a good question. I don't know the answer to it. My instincts tell me that you probably have to wait until the judge takes the office, because until they actually assume that office, you know, anything could happen. They could back out. Something could happen that would cause them not to be able to take office. That's just my instinct. It's a guess. But nevertheless, it's going to be very interesting to watch and see how this all plays out. We've got a lot of folks in the chat, and I want to see if anybody has any questions for me or for Sarah about any of this that you want us to get to. Before we finish up, there's something that happened today in a Fulton County courtroom that I think was hilarious, and you may know what I'm talking about, but it involves the YSL trial, which is another case, large case, where Fani Willis and her office, that's also a RICO trial, isn't it, Sarah?
Yeah, I believe so. I'm not been following that closely, but everyone is telling me I need to start following it. But it's just
look, I don't have the bandwidth to follow it like I need to, but something crazy happened. Okay, here we got a question here. I didn't pre-screen it, so sorry, but Cindy's asking, how political is McAfee when it is Kemp that appointed him, and Kemp is a rhino? It seems the judge wants this case to move forward. Well, you know, I'll let you have your opinions, Cindy, about your Governor Kemp, but it is true that Kemp appointed Judge McAfee. And so Judge McAfee before that I think he was in the Inspector General's office. He may have been the Inspector General in Georgia, which is another political appointment. Before that, though, he worked as an assistant district attorney in the Fulton DA's office. He worked for a Democrat, the predecessor of Fani Willis. And, you know, so I don't know that we can really say, you know, how political he is. I do think he would lean right of center. What's your take, Sarah?
You know, this is just my opinion, but it seems that I've certainly never been appointed to anything. So I'm assuming you've got to be quite political. And I think, I have absolutely no suspicions or worries or concerns that Governor Kemp is instructing the judge on how to handle this disqualification at all. But there's sometimes when you're so in alignment with someone politically, they don't have to tell you how to handle it. And if if the judge is aware of Governor Kemp's position on President Trump, perhaps that has some weight on how he handles it. It's not that there has to be a outward discussion, or I don't have any accusations. I'm not saying anything like that, but you could guess how how you would have to rule in order to get the approval of your governor. It would be a pretty simple guess, in my opinion.
Okay, Professor Nez asked, what do we think will happen with the Senate Judiciary Committee helmed by Senator Cowsert? Will he pursue Fani on financial grounds? I'll answer, then I'll let Sarah give her answer. But my answer is that the Senate. Well, wait a minute. We're talking about, okay. We're talking about the Senate Judiciary Committee. I guess there's the Georgia. There's this U.S. House Judiciary Committee, and you got the Georgia Senate. I think this is referring to the Georgia Senate. The Georgia Senate has its own committee. It's not really the Judiciary Committee, but it is a committee. I think it's called the Committee on Investigations or something like that. But it was created literally to look into this issue with Fani Willis and what's going on with her. And all the Senate can do is propose legislation that would take effect, if at all, after next year. And so they could pass laws dealing with how DA's offices are funded, how conflicts of interest are dealt with, and more oversight, but they can't take any direct action against Willis, at least not right now. And any action they take will be legislative in nature and would have to apply to all prosecutors in the state. Sarah?
No, I agree. I think what's interesting about that hearing that they had where they subpoenaed Ashley Merchant to testify, and I apologize, my lights just went out. I hope you can still see me.
We can see you.
The minority leader, at the end, he was really kind of cross-examining attorney Ashley Merchant, and he made a point to say that, you can't cure this. If there is a conflict, you can't cure it by removing weight. And then that's exactly what has happened so far. But I agree. I don't think that they actually have anything that they can do. They can create legislation. They can get a lot of information. They can do some great investigations, and then with that information, potentially create some legislation. But I don't believe that they have the authority to disbar her. They can make recommendations, but that's, I think, the extent of it. I think, the stronger arm in this is probably the Georgia bar. And then I'm really interested to see how the prosecuting attorney qualifications committee, if I got that acronym correct, I'm really interested to see how that plays out, and what actions they're taking. I know I've heard, the rumor mill has been that they've also been very concerned at doing some investigation into DA Deborah Gonzalez in the Athens-Clarke County.
Right. And that's she's the one that's where the Lake and Riley murder case that you may have heard about. And that's something we're going to be talking about here as well, as that horrible case involving the murder of Lake and Riley at the University of Georgia a few weeks ago. Kathleen asks, what if the Fulton County commissioners refuse to give her more funding for a new special prosecutor? It's interesting that the Fulton County Commission is investigating this. They want answers, and they don't want to give her a whole lot more money. I think they denied a request for her to buy like 16 new cars for the office or something along those lines. Sarah, have you heard what the Fulton Commission is doing?
No, actually, I wanted to ask you. So the Fulton County Ethics Board refused to hear the complaints that were filed against Fani Willis, and I'm assuming, is that sort of like a little subcommittee of the commission? Is that a completely different organization? I wasn't clear.
Yeah. All right. So we're talking about the Fulton County Board of Ethics, and the issue there, the same complainant, Mr. Kramer, filed one of the complaints with the Board of Ethics, Fulton County. Willis is a constitutional officer, and as such, she answers to the voters. She's not hired by the county commission. And as such, even though she gets a check, they can't fire her. The only people that can fire her are the voters, or if she's prosecuted by the attorney general and indicted, perhaps she could be then removed by the governor. But until then, that's really about it. So they have decided that, they don't have any authority to discipline her as a constitutional officer. This may not be a popular opinion, but I tend to agree with them. I think that's right. I think if you're the head of like watershed management or something like that at Fulton County, and you're giving out no bid contracts illegally, then they can come after you, because that's not a constitutional officer. And by that, I mean, that person doesn't hold an office that's created by the state constitution and, filled by a popular election.
So it's a completely, the ethics board it's not a little subdivision, a little committee of the Fulton County Commissioner, is what you're saying.
Yeah, it's the entity is the Fulton County Board of Ethics that's created by the county commission, but they are there to police ethics of like employees of the county. That's basically my take on the whole thing. The state ethics board is different. They have a little bit of power, but their power deals with campaign finance issues. So really, we're looking at the bar as being the appropriate entity to take any corrective action that they may feel is appropriate. And then if there's actually a procedure where somebody could submit an affidavit to a superior court judge involving, allegations of misconduct by an elected DA or a constitutional officer, and then in which case that judge would have to refer it to the attorney general. So unless there's some earthquake of a seismic shift of, I guess, the political will to get this over to some independent third-party law enforcement agency, you're basically looking at the state bar, which is where we started tonight, was with the bar complaint. That seems to be but those things take a long time, right? They could take as long as they want to take. It could take 6 weeks, 6 months, or 6 years, or they may never act on it. We just won't know.
Right. I believe also perhaps the Secretary of State within their campaign finance division can potentially do some investigations and perhaps, I don't know, perhaps I've read things in the past where someone didn't file a disclosure, and the Secretary of State, the campaign finance department, I think they fined them or something like that. So I'm sure that they have some sort of investigative authority to look into campaign finance violations.
Well, Cindy just corrected me. She pointed out, no, they approved the cars. Well, that one slipped by me, and maybe they did, but it was interesting that at least at first they denied the request for the cars. But the Fulton Commission, I think by and large, the majority of the commissioners probably are politically aligned with Miss Willis, and so eventually she's probably going to get what she wants. So I want to switch, and if this doesn't work, this is completely my fault. It's going to be user and operator error. But I want to see if I can go ahead and add this particular. Let's see. I want to get into what happened today with the YSL, and where was it? If I could do this, here it is. So this is the YSL trial. We had the witness for the prosecutor say, that they were, he said, I'm so high right now, Your Honor, I'm about to go to sleep. Let's see if I can play this.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
I'm so high right now, I'm about to go to sleep on y'all. That's Fulton County. That's a state's witness. That's somebody who is, called to testify by the office of the district attorney. Have you ever seen any such a thing, Sarah?
Oh man.
What would Judge Sarah Hobson do if that witness was in your courtroom? What would you do?
They would be held in contempt of court. I mean, yeah. I can't say I haven't seen witnesses who were high on the stand, but it was swiftly handled by the judge. Court was we took a break, and I believe they were escorted to a little holding cell, and they were ordered to go downstairs and take a drug and alcohol test. I've had people who were not under the influence of anything who were required to do that.
Yep.
So,
well, there you go. More of Fulton County causing, I guess, becoming the laughing stock of the legal world right here in our own backyard. Well, I appreciate you taking the time to come in here tonight. We've been going at it now almost 50 minutes. So we'll go ahead and say good night. I want to say, I'm glad you're here. I want everybody to, like I said, you would go back and watch this. Sarah's a great resource, great lawyer, knows a lot about these things. Check her out on social media. Where can they find you, Sarah?
I'm not super active on any social media. I do have a Twitter account, but if you go to hobsonlegal.com, we have all of the information about our firm on there. I hope to become a little more active on social media in light of all these interesting cases that are going on. Unfortunate, but interesting cases. But hobsonlegal.com, that's HOB as in boy, SON, legal.com.
All right. And with that, Sarah, good night, and we appreciate it. And thanks to all of you for coming in here and participating in the video and for the great questions. Sorry I couldn't get to more of them, but I do like to respond when I can to comments left on YouTube after the fact, even if you watch this later. So once again, I appreciate it, everybody, and have a great rest of your night.